Today, the Supreme Court had a chance to make history, to take up the most brazen, bald-faced manifestation of the Bush administration postulate that the president is above the law. And in our third story tonight, the Supreme Court said, not interested. Specifically, the court refused to hear the case of ACLU v. NSA, the National Security Agency. The agency, Mr. Bush, had wiretap Americans without court warrants in violation of U.S. law, including the FISA Act, specifically designed to curb government intrusions into Americans' privacy. The ACLU also asking in vain for the High Court to issue a ruling definitively affirming, and I'm not really dumbing this down by a lot, that the president of the country is not allowed to break the law. The Supreme Court declines to do so. That means a lower court dismissal of this case stands, the lower court ruling that the plaintiffs represented by the ACLU had no standing to sue because they can't prove they were wiretapped, because the government won't say who it has wiretapped, because the courts won't make it say who it has wiretapped, because the suit is being dismissed because no one has standing to sue because they can't prove they were wiretapped. And that, my friend, is where Joseph Heller got the idea for his novel Catch-22. Joined now by Jonathan Turley, professor of constitutional law at George Washington University. Thank you again for your time tonight, sir.
Hi, Keith.
That is the gist of it, right? I mean, you can't sue over being secretly wiretapped because you can't prove you were secretly wiretapped because it's a secret.
That is it in every ridiculous detail, and unfortunately that is a standard that is not unique. Why courts continue to use it is a very good question, because they have the ability, if they really wanted to force the government to make some minimal showing, even under seal, that would allow plaintiffs to get a ruling on the merits. But this is one of the reasons why many people have asked Congress to do something other than talk about this problem. Because, as you note, the courts have created an impossible test. People cannot prevail in getting even a review of the law.
To that point, though, if the lower court wanted an individual to prove he or she had been wiretapped, why would evidence like this entire AT&T room in San Francisco, we know the number of the room, we know the guy who hooked it all up, why is that not sufficient to at least move this lawsuit on?
Well, that's part of the ridiculous element to all of this, that we know there's an NSA program. We know that it's illegal. There's been no showing, nor is no showing possible, that the president had the authority to order what he did. This is a crime defined under federal law. So there's no mystery to the program. There's not a particular debate as to its illegality. The only issue is standing, the ability of someone to come in and say, I can show I was individually harmed. And they can't do that because the courts won't give them the information they need, and Congress will do nothing to force out into the public the information needed to get this type of relief. And as you've noted, the Congress is going further in the opposite direction. They're trying to extinguish suits against telecom companies that have been successful.
Is there any kind of benign interpretation for this on the court's behalf, that the court wants to wait until Congress and the president finish that wrangling over FISA, over telecom immunity, and then address whatever legal questions remain?
Well, there could be something to that. The Supreme Court tends not to want to take cases that are in play in the political branch. Congress, while it hasn't done anything, could do something. Moreover, there are criminal cases where the facts would be presented in a more compelling light. I happen to be counsel in one of those cases. But what the court may be waiting for, that is the left wing of the court, is the best possible case to review this matter. Mm-hmm. That would probably come up in a criminal case.
All right, you mentioned the wings of the court. On the political end of it, 7 justices appointed by Republicans, 2 Clinton appointees, Justice Ginsburg, Justice Breyer. Both of them will be in their 70s when the next president takes office. Does the refusal even to say, essentially, the president has to obey the law, does it put the court composition front and center in terms of the November elections?
Boy, it sure does. If people want to know how important a president is, they need to look at what's happening in the last 2 years. You have cases where there is flagrant violations of the law, crimes ordered by the president, unlawful surveillance, torture of suspects, and you have citizens that are unable to get a review on the merits, to simply have a judge look and find that the law was violated. That's what happened happens when you don't have a court system that is willing to challenge to this degree the president. Now, I want to say that there are many brave judges out there. This administration has lost more cases than it's won. But when it comes to national security, too many judges defer too greatly to the executive branch.
The George Washington University law professor, constitutional law expert, Jonathan Turley. As always, John, thanks for joining us today.
Thank you, Keith.